Partnership, Business Law for Everyday Use by Alonzo Rogers Weed. Partnership. What is a partnership? A partnership is a relation existing between two or more persons who have joined together their money, goods, skill, and labor, or any or all of them, in some business in which they divide the profits or share the losses. Any incapacity in the way of making a valid contract generally is to the same extent an incapacity in the way of becoming a partner. In some states, where married women are given control of their separate property, they also have power given them to enter into partnerships, but the law is as yet very unsettled in regards to their legal position. The money or goods contributed by their partners are combined at the outset into one mass. The title of this mass then belongs to the partnership. Each partner owns an interest, but until dissolution, this interest is in the receipts from the business. At dissolution of the partnership, the property of the firm is divided among the partners after paying its debts. Sharing profits alone does not necessarily create a partnership, though it may be very good evidence of one. When it is used simply as a means of paying employees or agents, there is no relation of partnership between them and their employer. Different kinds of partnerships. General partnerships. This is the ordinary partnership, and each partner is personally responsible for the entire debts of the partnership without regard to what he contributes. Those persons who are publicly known to belong to a firm are called the ostensible partners. Others who contribute capital and share in the profits or losses but are not known to be partners are dormant or silent partners. Silent partners may be made liable for the firm's debts equally with the ostensible partners if they can be discovered. Limited partnerships. Where it is agreed that each partner shall be liable only for the amount of capital he contributes, it is a special or limited partnership. The restricted liability is only created by statute, and therefore the statute regulations in the different states in regards to them should be closely followed in their formation. Thus, in some states they must be registered or published, and in most of the states the capital must be contributed in money. In this kind of partnership, a partner's liability does not begin till all the capital is paid in. Joint stock companies. These are unincorporated companies which sell transferable shares. They are similar to corporations, managing their affairs by a board of directors and distributing the profits equally among the shares. Shareholders, however, are really partners, and unless their liability is expressly stipulated and publicly known to be limited to the number of shares owned, or is so stipulated by statute, they are liable to the same extent as general partners. Such companies are not very common in this country. How partnerships are formed. A partnership is usually formed by an oral or written agreement between the parties. If it is for more than 1 year or is not to go into effect within a year, the statute of frauds requires it to be in writing. It is customary for parties to enter into a written agreement called the Articles of Co-Partnership, setting forth specifically the terms of their agreement. It is certainly always advisable. The liability and authority of the partners begins with the actual formation of the partnership, however, which may be before the articles are executed. Where the agreement is not in writing, the actual intention of the partners will govern the terms of the partnership. The exact time for beginning the partnership, whether immediately or at a future date, should be clearly stated. A partnership may be created for life, i.e., till the death of any one of the partners, or for a term of years, or for an indefinite period, or even for a single transaction. It may be created to carry on any lawful business, but the partners must confine themselves to the business agreed upon. The partnership may consist of any number of partners who may transact their business under any firm name which they may adopt. In some states, however, restrictions have been put on firm names, such as in the use of "and company," where no partner is represented by the company. New partners can only be admitted by unanimous consent, but by the partnership's articles or by agreement, the capital of a deceased partner may be left in, or even his personal representative may take his place as a partner. In joint stock companies, which sell transferable shares, a purchaser of a share becomes a partner. If it is so provided in the articles, the personal representative of a deceased shareholder may take his place in the company. A partnership is often implied from the relations of certain persons together in business, though they have not expressly agreed to consider themselves partners. Thus, if certain persons in business have a common interest in the ownership of property and in the sharing of profits and losses, all the elements of a true partnership are present, and no express agreement is necessary to make them partners. Or where a partnership for a fixed period runs out and the partners still carry on their business as before, the law implies a continuing partnership under the same terms. The relations of partners to each other. In a partnership, each partner is principal for himself and an agent for all others. Each may therefore require the others to labor faithfully and diligently to advance the interests of the firm. But a partner would have no right to demand extra pay for his services, even if after dissolution one partner settled up the partnership affairs. He would have no right to extra pay unless it was so agreed. The partners may arrange among themselves how they will share their liabilities, but such arrangements, as will be seen hereafter, will not affect the rights of firm creditors, unless they know of them. No partner has a right without the other's consent to engage in any other business which competes with or is against the interests of the partnership. For example, he cannot use the firm as a market for his own goods to his own private profit. In the management of the partnership affairs, the partners have equal rights, even though their interests are unequal. Where there are more than two partners, a majority can control the ordinary action of the firm. In cases of fundamental importance, however, all must agree. The partnership articles ought to recite the occasions when a unanimous consent is necessary. Each partner has a right to the books of the concern, and each should carefully enter in them whatever he does. A partner may take goods of the firm for his own use and charge them to his own account, but the articles ought to regulate the amount that can be so taken. Each partner is in duty bound to keep his own money absolutely separate from the money of the firm. If the money of the firm is placed in a bank, it should be deposited in the firm name, and any one of the partners may draw out money so deposited. If a partner deposits money of the firm in his own name and the bank fails, he and not the firm will have to bear the loss. The power of partners to bind the firm. Each partner has the power to bind the firm on any contract within the limits of the partnership business, even without the knowledge or consent of the other partners. But the contract must fairly belong to their business, i.e., it must relate to some of the objects for which the partnership was formed. Custom will often help to determine how far any particular business may fairly be carried. If a written contract is made in the name of the partner, he will be personally liable on it, unless it can be shown to belong to the firm. If such a contract is in the firm's name alone, or in the names of all the partners without reference to the partnership, this is sufficient to render the firm liable. It would be better, however, if the names of all the partners appeared as doing business under a certain firm name. Each partner has a right to buy and sell goods in which the firm deals, to collect debts and give receipts, and to warrant goods if it is customary. He might even sell all the property of the firm, and ordinarily he has power to mortgage or pledge the property of the firm to secure its debts. But one partner cannot convey real estate without the consent of the other partners. All their names should appear in a deed or in a mortgage of real estate in order to make it a good conveyance to or from the firm. Thus, if the deed ran to Peter Smith and Company, Peter Smith alone would get the title to the real estate. He would hold, however, as trustee for the firm, and the other partners could compel him to convey it to them all. If it was the custom in the business, a partner would have the power to sign negotiable paper with the firm name and to borrow money for the firm by giving notes. But he could not bind the firm by a note given for his own debts. The firm name must be signed to negotiable paper to render the firm liable at all on it. On the other hand, the partner would not usually have the right to set off a debt owed to the firm against the private debt of his own, nor has he the authority to guarantee a debt or to endorse for a third person in the firm name. All the partners are liable for any act of negligence of one of their number, or for his fraud or willful misconduct committed in the course of the partnership business. For example, where a partner was overseeing some hoisting and a rope broke and a man was injured, or where a partner kicked a customer out of their store, or if he made fraudulent representations in the sale of goods, all the partners would be responsible. Even though the partners agreed to restrict this authority to bind the firm, this agreement is only good between themselves and does not change their liability to a third person who deals with one of them without a knowledge of this arrangement. A partner's relation to third persons. Persons who have expressly formed a partnership are, of course, liable as partners to all third persons dealing with them as such, i.e., each is liable for the entire debts of the firm unless it is a limited partnership. But if this third person knew of an arrangement among the partners by which, for instance, one had agreed to meet all the liabilities, he could probably then only resort for payment to this one partner. But persons are liable as partners to any third person to whom they hold themselves out as partners, or when their relations to each other would imply a partnership without an agreement to the contrary. The third person, however, must honestly believe them to be partners. Where persons are joint owners of property and share profits and losses, nothing further is needed to constitute them partners. Where persons share profits and losses, they may usually be considered partners by third persons and dealt with as such. Even when they share only the profits or only the losses, under most circumstances, they are partners as to third persons at least. But giving a percentage of the profits to a landlord to pay the rent of a store or as wages to an agent or salesman does not make them partners. Neither does one loaning capital at an interest proportionable to the profits, nor the personal representative of a deceased partner whose money is left in the business become a partner thereby. Nor does a retiring member who is paid for his goodwill out of the profits continue a partner. Creditors of the partnership have the first claim on the partnership property, while private creditors must be satisfied first out of a partner's private property before the partnership creditors can have their turn. In a number of states, it is held that a private creditor cannot attach partnership property on the ground that until dissolution, a partnership interest is simply in the return of the business and that the title of the property is in the partnership. A firm creditor should secure the separate signatures of all the partners to a note, and then he has a choice of proceeding as a firm creditor or a private creditor. Most states have homestead laws, which, for the protection of a debtor's family, exempt certain real estate which has been set apart as a homestead, under certain restrictions, from attachment or sale on execution by a creditor. All the states have exemption laws to protect property of certain kinds and a certain amount of money from creditors. Dissolution of a partnership. A partnership may be dissolved at any time by the consent of all the partners. If the partnership was formed for an indefinite period, notice from any of the partners at any time will dissolve it. Probably the other partners could require a reasonable length of time after this notice to arrange their affairs. Where partnerships are for a fixed time, the articles often provide for a dissolution at any time on a 3 months' notice. The following events will of themselves cause a dissolution. 1. The death of a partner. The partnership articles may, however, provide that this shall not dissolve the partnership. 2. A formal decree of bankruptcy against the partner or the firm. The bankruptcy must be judicially decreed. Insolvency simply is not sufficient. 3. The assignment by a partner of his assets in the firm to an outsider, or even to his fellow partners. Here again, the partnership articles may provide that the firm is to go on as before, or that the purchaser is to join it. 4. The termination of the time originally fixed for the partnership, but the partnership often continues under the same conditions, become a partnership at will. 5. A declaration of war if two partners are respectively citizens of the two nations at war. This would not be true of a rebellion. 6. The marriage of a partner who is a woman, unless married women are allowed by statute to be partners. The absconding, fraud, and misconduct, even in the conducting the firm's business or in forming personal habits which interfere with the performance of his duties, or insanity of a partner, or his inability to perform his part of the agreement, as in putting in capital, or the impracticality of carrying on the partnership business by any reasonable means, are all are good grounds on which to ask a court of equity for a dissolution. Upon dissolution, the power of the partners to bind the firm ceases. The property of the firm must then be applied to the partnership's liabilities. After paying the debts, if there is a surplus, the partners share it according to their different interests in the partnership. If the dissolution is caused by death, the deceased partner's interest goes to his estate. Unless the dissolution is caused by death or bankruptcy, the public should be notified by newspaper notice or by circular, or in both ways. Else the partners will still be liable as a firm to persons without notice of the dissolution. Voluntary associations. The great distinction between a partnership and a corporation lies in the individual liability of their respective members. A corporation is a legal person quite distinct from its stockholders, both in its internal management and its relations with third persons. Its existence is not affected by the death of a stockholder or by the sale of his shares to another, nor is a stockholder individually liable for its debts. With a partnership, all this is quite different, as the preceding pages have shown. There are certain unincorporated companies known as voluntary associations, which are like corporations in their organization and management, and yet are partnerships so far as third persons are concerned. Instances such as master builders or mechanics associations or milk producers in the vicinity of large cities associations are quite common. The membership of such an association is usually large, and its object is not ordinarily to carry on a single business enterprise, but rather to advance the individual business interests of its members by cooperating to secure a suitable common meeting place, or to establish from time to time common rates, or to obtain better facilities for transportation. These associations are usually organized, as are corporations, under bylaws or a constitution, and are managed by boards of directors or trustees and other officers. The terms of such organization are binding on the members as between themselves, but in their dealings with outsiders they are generally considered partners. Consequently, each member of such an association becomes individually liable for all the debts, although of course he could force his associates to contribute their respective shares in case he had to pay. A member does not rid himself of this liability by retiring from the association unless the creditor is aware of such fact. This manner of individual liability and certain difficulties in regards to the title of the property, which cannot be briefly explained, are serious objections to such associations.